We are set today for a hearing on defense's motion for treatment in lieu of conviction. The state does not oppose the intervention. The defendant has 93 days jail time credit, and the state is seeking a $1,000 deductible and restitution. Thank you.
Ms. Smith, would you like to be heard on your motion?
Yes, Your Honor. On behalf of Mr. Bickley, Your Honor, we are asking the court to grant the pending motion for intervention in lieu of conviction. As the court is aware, Mr. Bickley has been screened by probation and was found to be eligible under both the substance use and mental health prongs of the statute. Your Honor, Mr. Bickley is 18 years old and picked up his first felony very shortly after reaching adulthood. Through the course of my representation, we've developed the understanding that Mr. Bickley turned 18 and very much was without resources. In fact, one of the delays in getting him established in treatment is that he did not have insurance at the time, so our office assisted in getting him established with Medicaid so that he could participate in treatment should the court grant the motion. Your Honor, Mr. Bickley has no ties to Lake County, and he came to Lake County from Toledo, where he also had no ties. Essentially, Mr. Bickley was wandering aimlessly, heavily off of his mental health meds and under the influence of alcohol and drug choice. Okay. Your Honor, Mr. Bickley has indicated a desire to use the court's intervention program as an opportunity to obtain the tools and resources that he does not have as an 18-year-old so that he can learn how to navigate and manage adulthood on his own as a productive and contributing member of society. Your Honor, our office has begun the screening process for Mr. Bickley at different community providers. It's my understanding that he has been accepted to Lake House. However, he is on a waiting list for a bed to become available. So, Your Honor, for those reasons and in light of his youth and lack of a criminal history, we would ask the court to grant the motion for intervention in lieu.
Thank you. Mr. Bickley, is there anything you'd like to say in regards to your request? I'm assuming your lawyer has explained to you what intervention in lieu of conviction is, but I'm going to do that at this point. It's a request that you're making of the court alleging that you committed this offense due to a drug dependency issue and or mental health issue, and you're asking that you be placed under the supervision of the probation department with a plan put in place to help you deal with these issues that brought you here, and you're basically put on a period of supervision for some period of time, and if you successfully complete the intervention plan, the charges get dismissed. They're gone, so you won't have a felony on your record, which is a big deal this day and age, especially with your age. If you fail to comply with the intervention plan, then you would have the conviction. We would come back here if I found that you did violate the plan. I'd enter the guilty conviction and I'd sentence you. But it's a pretty extraordinary request because of the end result, because you commit a felony which you don't have it on your record. Why is this something that you think you're deserving of?
Well, I mean, I'm not really sure. I mean, I've never been in trouble before.
Maybe it's not a fair question. Let me ask you this. In order for me to find you to be eligible for this, excuse me, I have to find that you are able and willing to comply with the conditions that this court sets forth and the rules of probation. You haven't been doing too good of a job of that in the jail, with the trouble that you get into there. In regards to following rules, following what the COs tell you to do, it seems like if you disagree with that, you don't do it. You do what you want to do. You argue. That's not going to cut it on intervention of conviction. And even in this process, you're going through this referral stage, and we wanted to have you interviewed by someone, and you refused to even talk with them. You say you want to get help, but you refuse to meet with the folks from NeoCap to even be interviewed. Why is that?
Well, I thought I'd be going to the lake house. I mean, I still want help. I would prefer to be at the lake house instead of.
Well, you don't make that decision, though. I make that decision. You don't just get to say, this is what I want, and that's what happens.
Yeah.
We wanted to have you interviewed to try to determine which would be the more appropriate place. All it was an interview. And it was explained to you what that was all about, and you still refused to talk to them. If you were sitting here, how would you view that? If you're applying to the court to try to get help and they have you being interviewed by an agency, not prison, an agency to get help, and you say, I'm not talking to you. And how would you, if you were me, be viewing you at this time?
That I didn't want the help, or
Sorry?
that I didn't want the help, maybe, but.
Or you want it on your terms, the way you want to do it, and if it's anything different, then we're going to have a problem. That's not going to work if I grant this. You understand that?
Yeah, yes, sir.
You're not going to be the one that dictates. I'm not just going to put conditions or orders in place for the heck of it. They're going to have a purpose behind them. You may disagree with it. You may not see it. You may think it's not necessary. But even if you do feel that way, you're going to have to comply with it. Even if you think it's some silly reason, it's not necessary, unreasonable, you're gonna have to go along with it. You understand that?
Yes, sir.
If you go to some residential treatment center, wherever it is, whether it's NeoCap, Lake House, Concord Pines, whatever it is, they're gonna have rules you have to follow. You're gonna have to follow them, and they may be petty rules. But they're rules nonetheless that you have to comply with. And if you don't, they're gonna kick you out, and you'd lose this. You understand that?
Yes, sir.
You gonna be able to do that?
Yes, sir.
All right, well, I'll give you a chance with this. I'll find you're eligible for intervention in lieu of conviction. I'll give you an opportunity to demonstrate that. Like I said, in jail, there's been several incidents here which you haven't. But I'll give you an opportunity to show that you can do that. I'll find you're eligible for intervention in lieu of conviction. And it'll be my intention to grant your motion. But before I can do that, you have to enter a plea of guilty to the charge. Assuming that plea of guilty is forthcoming, I will then grant your motion. But before I can accept your guilty plea, I need to make sure you understand everything that's going on here. You need to make sure you understand what you're pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a bunch of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, want a moment to speak with your lawyer to ask your questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing here, all right?
Yes, sir.
All right. Let's get started then. How old are you?
18.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No, sir.
All right, I'm going to ask, since we don't have the court reporter, that you just speak up a little louder and make sure that gets picked up. You don't need to lean forward, but just keep your voice up a little bit. I forget where I left off, yeah. In the last 24 hours, have you had any drugs or alcohol of any kind?
No, sir.
I said 24. What about in the last past 48 hours? Not even prescribed medication, nothing?
No, sir.
Now, you should have received a copy of this indictment previously. Do you remember getting that?
Oh, yes, sir.
You had a chance to look that over?
Yes, sir.
Now, in the indictment, you're charged with one count. What's alleged here is on or about, and this is what you're going to be admitting to, on or about August 31st, 2025 in Painesville Township, Lake County, Ohio, that you did receive, retain, or dispose of certain property, being a gray 2018 Honda HR-V, which belonged to another person, owned by another person, being Michael Brough, B-R-O-U-G-H, and that you knew or had reasonable cause to believe that that motor vehicle had been obtained through the commission of a theft offense. The property involved is in fact a motor vehicle, which makes the offense receiving stolen property a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions for me about it?
No, sir.
Well, before I can accept your plea, I need to make sure you understand all the rights you're giving up, and you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present the jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. Unanimous means all 12 jurors have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it's his job, or he bears the responsibility or the obligation to prove you guilty at a trial before you can be found guilty. You're presumed innocent of this charge, and that presumption of innocence will remain with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case, that burden of proof is called proof beyond a reasonable doubt. Highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge I just read to you beyond any reasonable doubt before you could ever be found guilty of this charge at a trial. Do you understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to try to do that, if we're going to have a trial here, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right, at a trial, you can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
You further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you also have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes, sir.
You further understand that if we did go to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you normally are giving up any right you have to appeal a guilty finding that's made, or any other issues you could raise. Now, I'm not going to be making a guilty finding today. As I told you, I'm going to accept your plea, but then I'm going to hold off on finding you guilty and I'm going to put you under the supervision of the probation department. But you are giving up any right you had to appeal any other issues you could have raised up until this time. You understand that?
Yes, sir.
And further, if we should have to come back here because you didn't comply with the terms of the intervention plan, and certainly we're hoping that doesn't happen. But if we did that and you were found guilty, then you're waiving your right to challenge the guilty finding. You understand that?
Yes, sir.
You can still challenge perhaps the reason why you violated it, but you couldn't challenge being found guilty. You understand that?
Yes, sir.
All right, well, do you have any questions at all regarding these rights we've just discussed?
No, sir.
You understand them all?
Mm-hmm.
Do you still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? So you're going to be admitting to the facts being alleged here that you did this. We're not going to argue you didn't do it, someone else is to blame, anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of a guilty plea normally is that you're found guilty and sentenced. Again, that's not happening here. I'm going to accept your plea. I'm going to stay off further criminal proceedings, which means putting off or postponing, not doing it today, finding of guilt and sentencing. I'll put you under the supervision of the probation department with certain conditions to comply with. If you do, the case gets dismissed at the end of that period of time. If you don't, if you violate any of the conditions, we'll come back here for a hearing. And if at a hearing I find that you did violate the conditions, at that point I would lift or vacate the stay of criminal proceedings. I'd find you guilty of the charge that you're pleading to today, and then we would proceed to sentencing. So even though we're not going to go to sentencing, and hopefully we're not going to go to sentencing at any point, I need to make sure you understand what those potential penalties could be if something were to happen. So I'm going to review those with you at this point, all right?
Yes, sir.
If we had to proceed to sentencing, I could, this offense you're pleading guilty to is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. You understand that?
Yes, sir.
I'm pretty sure I know the answer to this, but let me just hear it from you. Do you have any other charges pending against you right now?
No, sir.
And are you on probation or parole or any supervision in any of the courts?
No, sir.
All right. If a prison sentence is ever imposed upon your release from prison, you could be placed on what's called post-release control, sometimes called parole. It's a period of supervision you would be on after you completed the prison sentence. And in this case, it could be up to 2 years. You understand that?
Yes, sir.
If you were ever on post-release control and violated any of the conditions of your supervision, we would have a hearing, the parole authority would have a hearing, and they could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, in addition to any possible prison sentence I just mentioned, there's other sanctions that could be ordered. Some will be. I could order that you be fined up to $5,000 if we proceed to sentencing. You understand that?
Yes, sir.
I will order that I could also order that could happen for intervention in lieu of conviction, that you pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, sir.
I could also order, and I will as part of intervention in lieu of conviction, that you make restitution to the victim for whatever economic loss the victim suffered. In this case, the victim's out of pocket $1,000 for a deductible that he had to pay, so that would be subject to restitution. You understand that?
Yes, sir.
Now, a few moments ago I explained what the possible prison term could be if we had to proceed to sentencing. I used the word possible. Prison's not mandatory or wouldn't be mandatory necessarily if you violated intervention of conviction. You could be put on probation at that point, or what's called community control sanctions. Do you understand that?
Yes, sir.
Now, just because you'd be eligible doesn't mean you'll automatically get probation. It means I'll consider that. I'll certainly look at the reason why we're back here and what happened to get us back here. And I'll make the decision I think is the right thing to do. You understand that?
Yes, sir.
Now, if you were put on community control sanctions, it could be up to 5 years. And as the judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve time in the Lake County Jail of up to 6 months. Do you understand that?
Yes, sir.
Further, if you were on probation at any point you ever violated the conditions of your probation, we would have a probation violation hearing. If it was determined that you were, I could extend your probation up to 5 years, could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, again, it could be 6 to 18 months, and that could be consecutive to any other sentence you may be serving for something else at that point. Do you understand that?
Yes, sir.
All right, well, you understand all the possible penalties you face if we ever had to proceed to the sentencing hearing?
Yes, sir.
Any questions for me?
No, sir.
You still want to plead guilty?
Yes, sir.
Have you had enough time to talk about this case with your lawyer and have her go over everything with you and answer all your questions?
Yes, sir.
Sorry?
I said yes, sir.
Are you satisfied with her advice and counsel?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty here?
No, sir.
Are you entering a guilty plea freely and voluntarily?
Yes, sir.
All right, then, do you have any questions for me at this time regarding anything we've just talked about, the rights you're giving up, possible penalties you could face if we proceed to sentencing? Any questions about what you're pleading guilty to? Any questions at all?
No, sir.
You need any more time to speak with your lawyer before we go forward with your plea of guilty?
No, sir.
All right, then what's going to happen at this point, the prosecutor is going to explain for me what he thinks the facts would show if we went to trial. I want you to listen to him because I have some questions for you about that, all right? Mr. Knopf.
Thank you, Your Honor. Had the case proceeded to trial, the state would have shown that on or about August 31st, 2025 in Painesville Township, Lake County, Ohio, the defendant was knowingly in possession of stolen property, that property being a Honda HR-V. Specifically on the night in question, that vehicle was stolen out of a driveway in Toledo, Ohio. The vehicle was then recovered in Painesville Township after the defendant crashed it. He was caught on a ring camera exiting the vehicle shortly after crashing into a telephone pole.
Mr. Bickley, were you able to hear what the prosecutor just had to say regarding what he believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, do you have to say about those facts as he represented them? Are they true? Did you do what he said?
Yeah, they're true.
Very well, then, regarding count 1 here, charging with receiving stolen property, a felony of the 4th degree with the property being a motor vehicle. What is your plea at this time?
Guilty.
All right, I have in my possession here a 4-page document called the written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. My understanding is before I walked out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, sir.
Ms. Smith, is that accurate? Did you read that over with Mr. Bickley, review it with him, answer his questions?
I did, Your Honor, and he indicated an understanding of the document.
Is that correct, Mr.
Yes,
Bickley? You understand what it says?
Yes, sir.
Any questions for me about it?
Yes,
It
sir.
also appears that you signed the document. Did you sign it?
Yes, sir.
And you witnessed that, Ms. Smith?
I did, Your Honor.
Mr. Knopf, you as well?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer. Advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that could be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea to count 1, receiving stolen property, following the 4th degree in violation of 2913.51 of the revised code. While I'll accept the plea, I'm going to, at this point, grant your motion for intervention of conviction. I'm going to stay all further criminal proceedings, which include the finding of guilt and sentencing. I'm going to place you under the supervision of the Lake County Adult Probation Department for a period of 2 years. And I'm going to order the implementation of the following intervention plan. Second. I'm going to order at this point you serve 150 days in jail. You have credit for 93. However, as soon as a bed's available at either Lake House or Concord Pines, and those two are basically the same type of. Does he understand Concord Pines and Lake House? I know he was talking about Lake House the whole time, but it's the same. They're owned by the same people. They run the same way. It's the same, just 2 different places.
Yeah, I understand.
But whichever has a bed available first, I'll allow you to be released from the jail at that time. So the extra jail time is just to make sure we have enough time for that to happen. It should be more than enough. You're to enter either Lake House or Concord Pines and successfully complete the programming there. Follow all their aftercare recommendations. Upon completion of that program, you are to reside in a sober living residence for at least 6 months. You can stay longer if you want, but at least 6 months you're to reside in a sober living residence facility. Follow all their rules. You can't get kicked out of there. Further conditions, not to use any drugs or alcohol. You'll have to submit random urine screens. They must be negative. A positive screen will be a violation. You can't tamper with the urine sample in any way. bringing fake urine, someone else's urine, anything like that. You understand that?
Yes, sir.
You're to attend 3 AA meetings a week and have a sponsor. I want you to get a mental health evaluation. And that's something that could happen at the residential facility. And follow whatever recommendations are made for any type of mental health counseling or treatment. Take any and all medications as prescribed. Pay your court costs and supervision fees. And I'm going to order restitution in the amount of $1,000 to the victim. Mr. Randazzo, anything else I should be considering here?
Yes, Your Honor, to obtain his GED, he has a...
Oh yeah, we talked about that. I want you to make a reasonable effort at obtaining your GED also, all right?
Yes, sir.
So Mr. Bickley, you understand all the conditions of the intervention plan that we just put in place?
Yes, sir.
Any questions for me?
Yes, sir.
All right, I need to advise you, if you fail to comply with any of these conditions or any of the rules of probation, they're going to go over those with you as well. If any of that should happen, if you left Ohio without permission from the court, if you committed another crime, obviously. If anything like that should happen, a motion to terminate your intervention in lieu of conviction would be filed. If it's found that you did violate, at that point I would vacate the stay of criminal proceedings. I'd find you guilty of this charge and we proceed to sentencing, where any of the potential penalties that I just reviewed with you could be imposed, including a prison term of 18 months. You understand that?
Yes, sir.
And that could be consecutive to any other term that you may be serving for some new case that should occur. All right?
Yes, sir.
All right. I'm going to give you a chance to try to get back on track here and